Good evening. My name is Anthony Jackson, President of the Delta Xi Lambda chapter of Alpha Phi Alpha Fraternity Incorporated.
Good evening. My name is Jamil Solomon. I'm the Vice President and President-elect of the Delta Xi Lambda chapter of Alpha Phi Alpha Fraternity Incorporated.
We would like to welcome you to our community forum, a forum that discusses the critical issue of the standing ground law regarding the Zimmerman case and the use of it in the death of Trayvon Martin. This was an important issue that has caused people to galvanize together to seek change of this law or repeal the law altogether. But before we can seek to change anything, we must first educate ourselves on what the law means, how it's interpreted in terms of jury instruction, and also how law enforcement will use that law to enforce what happens at a crime scene. And so tonight was about empowering people, giving them the tools and the knowledge and information they need to make critical decisions that will impact their lives and their community. And that's what we're seeking to do this evening.
I want to thank all of you for being here today. Obviously, you did not have to be here, but this is a discussion that we all need to have. My job as moderator will be to facilitate some of the original questions, but your job as people that are here will be to ask some of the follow-ups as well once we dive further deeper into the last 15 to 30 minutes of this night's discussion. We'll be talking about a range of topics, obviously focusing on the major ones, including stand your ground law, the verdict from this case, and the different other issues that have come because of the verdict from this case. The reason we're all here today is because on February 26, 2012, George Zimmerman and Trayvon Martin met in a Sanford neighborhood, and it ended with Trayvon Martin dead. What happened that night will not be argued here today, but the result of that night and the law surrounding the case will be our focus. Now, in reality, this case got the exposure, but the issues that have come from the shooting and the verdict have been a part of our national discussion since our nation was first formed. Now, here today, we have a very special group of panelists joining us to discuss the verdict, the stand your ground law, self-defense laws, what needs to be changed or modified, and what needs to stay the same. Now, while I will be structuring the majority of the discussion, this is a town hall, as I just mentioned, and your input is necessary to keep the conversation going. We welcome your input and questions. Now, please allow me to introduce our esteemed panel. I want to start with Mr. Kamar Williams, who you just heard from the Williams Law Group. He went to Sacramento State for undergrad and did his law degree here at FAMU. Though he is the person who was the driving force in organizing this and made sure that I had biographies on each one of our panelists, he did not include himself because he is modest enough to know that he is just here as a participant, not as one of the leaders of this. But we do respect the fact that he will be sitting on this as one of the leaders who actually formed this event and will have a great opinion, Mr. Kamar Williams. To the far end of the table, Associate Professor of the Florida A&M College of Law, Professor Patricia Broussard. Broussard comes to FAMU from Howard University, where she taught for 7 years. While there, she was the acting director of the writing program. She received the Warren Rosmarin Award for outstanding teaching and service because she and a colleague supervised 4 students in writing a brief to the U.S. Supreme Court in the case of Grutter versus Bollinger. Outside of school, Broussard serves as a commissioner for the MLK Project and Commission here in Orlando. She developed and implemented an annual cleanup project in Paramore and mentoring her students outside of work. Now, she received her JD from Howard and her BS from Northwestern University. Ms. Broussard. Closer towards the middle, we have the esteemed Florida Senator Geraldine Thompson. She joins us as well this night. Senator Thompson received her bachelor's degree in journalism and business education from the University of Miami in Coral Gables. She and her husband then moved to Tallahassee, where she attended law school and worked in state government and higher education. She also received a master's in science from the Florida State University. Upon leaving there, she taught in Orange County Public Schools, then moved on to Valencia Community College, where she served for 24 years as the assistant to the president. Now, she was first elected in 2006, ran unopposed in 2008 and 2010, and in 2012, Thompson won her current position as a Florida State Senator. Ms. Thompson. Back towards the other end of the table, Attorney Natalie Jackson. Ms. Jackson is one of the Trayvon Martin family attorneys and has played a major role in this case since the very beginning. Attorney Jackson received her BA from Hampton University and her JD from the University of Florida. She is best known for her work in advocating for the legal concerns of women and for her work in personal injury to children and wrongful death. She is a former naval intelligence officer, among the first group of women deployed aboard an aircraft carrier. Her perspective on this trial and case has been broadcast throughout the world, and we look forward to her comments and subject matter here today. Ms. Jackson. To her right, Senate Minority Leader Chris Smith is a member of Alpha Phi Alpha Fraternity Incorporated and the Democratic leader of the Florida State Senate. The Fort Lauderdale attorney received his bachelor's degree from Johnson C. Smith University in Charlotte, not far from my hometown. and graduated from the Florida State University College of Law in 1995. Senator. Senator David Simmons is closest towards my side. He is the majority whip of the Florida State Senate. Before the Senate, Simmons served as a member of the Florida House from 2000 to 2008. He was sworn in as a senator in 2010. In his time in public service, he has received the Distinguished Advocate Award from the Chamber of Commerce in 2005 and 2006, the Christian Coalition of Florida Faith and Family Award in 02, 03, 04, and 06, Florida Association of Professional Process Service Legislator of the Year in 2005, the Florida Legal Services for commitment to assuring equal access to justice at the Supreme Court of Florida in 2005. Now, his awards vary from law enforcement awards to public radio and television to Mothers Against Drunk Driving. He received his BS from Tennessee Tech University and law degree from Vanderbilt University. He is the author of the Stand Your Ground Law, and we thank him for being here with us tonight. Now to begin the discussion, I want to begin with the verdict in this case, and as you all know, we are less than 2 weeks removed from the jury's decision to acquit George Zimmerman from second-degree murder charges and manslaughter charges. Now, in my hand, I have a copy of the jury instructions here that they actually took into the room with them when they decided that decision. On 3 different occasions, it mentions justifiable use of deadly force and specifically uses the phrase "stand your ground" on page 12 in the document. It says that George Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had a right to be. He had no duty to retreat and had the right to stand his ground and meet force with force, including deadly force if he reasonably believed that it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. Now, I want to open the discussion with the professor. Professor, your thoughts simply on the verdict and if that law, now known as stand your ground that we've all called it, was relevant here, and please explain the difference between stand your ground and also self-defense.
Okay, can you hear me? Yes. All right, good evening, and thank you very much, and thank you for the panel. It's a pleasure to serve with you. I teach constitutional law, and because I teach constitutional law, I come from a constitutional law perspective. So before I go into answering the question that I was asked, I have to just tell you that on June 23rd, 2013, the United States Supreme Court decided Shelby County versus Holder and essentially neutered the Voting Rights Act. Many people didn't know about the Shelby County case before it came before the court. The case that we've come here tonight to discuss is directly correlated and related to this case, to Shelby County case. And it's related because even though there's no hierarchy of fundamental rights, as I teach my class, voting is one of the most compelling rights there is because it bestows upon citizens the political liberty to elect officials who represent us. There are individuals of both parties who enact legislation without consulting the persons who will be impacted by it to the greatest extent. These are the individuals we elect to protect those other fundamental rights. So voting is absolutely important. We cannot sleep and allow legislators to pass laws which have not been vetted in our communities, which directly impact us, and which work to our detriment. Do not overlook the Shelby County decision and the role that voting plays in Stand Your Ground and any other law that impacts us so detrimentally. That's what I want to say about voting. Don't sleep on what has happened to us. With respect to Stand Your Ground, I've heard a lot of people say that, well, the Stand Your Ground law didn't really apply here. It did apply. It played a role because the presence of the statute on the book required the judge to give the jury instruction she gave, which mentioned Stand Your Ground. And it possibly confused or empowered the jury, depending on what your perspective is. Stand Your Ground also played a role because by allowing the use of deadly force, it gives courage to individuals who don't have the courage but have a gun in their waistband to act when they would not act. Stand Your Ground played a role because it creates a Wild West environment which allows for the death penalty for any infraction where the aggressor, as in the Zimmerman case, felt threatened. The law rewards the Wild Wild West mentality. Now, I argue that the law doesn't meet constitutional muster, and here's why. If a law is written in such a way in which jurisdictions don't know how to interpret it, or interpret it differently when the same set of facts is in front of it, then it is vague. And as Constitutional Law 1 students know, when a law is vague, you strike it. As a result of the subjective application of the law, it also violates equal protection, as we have come to interpret equal protection. It violates both the equal protection of the person who is killed as a result of the independent actor, and it violates the rights of the person who does the shooting, stabbing, killing, etc. I also maintain that it violates the 8th Amendment because it is cruel and unusual punishment. Now, I'm just going to do a hypothetical just very quickly to illustrate that. Let's suppose that there is a young white girl. Let's suppose she's 16 years old. Let's suppose she's walking home one night in the dark, in the rain, and there's somebody following her. She's been taught all her life about stranger danger. She's terrified. She doesn't know who this person is. She turns around and she pepper sprays them. Well, as it happens, it's just somebody who lives in her neighborhood who's just walking behind her. He shoots her. She dies. Can we now say that this young lady deserved the death penalty? Let's look at it another way. Let's say she looked behind her and she recognized the person. But she'd been itching to use that pepper spray. She just wanted to know what it was like. So she sprayed the guy, even though she knew she probably knew him and he wasn't going to hurt her. And let's say he shot her. And let's say she survived. She's charged with assault because she initiated this. Would she have been given the death penalty if the court found her guilty of simple assault? No. That's
Professor
absurd.
Broussard, I'm going to reel you in here because we are going to talk about
let me
race
just finish the line. However,
go ahead, please.
Trayvon Martin received the death penalty. So you're giving citizens the ability to administer the death penalty for infractions where the death penalty would not have been administered had the crime actually been committed and the person been found guilty. Therefore, I submit in conclusion that it also violates the 8th Amendment of the Constitution, and I have some more to say later. Thank you.
Broussard, as we are continuing our discussion, I want to pivot now, and we will definitely hear from Senator Simmons, the author of the law, to talk back about the fact that you said it was too vague in just a moment. But I want to go first to Natalie Jackson. You have been there from the very beginning. We have seen marches across the country. The group called the Dream Defenders locked inside the rotunda in the Florida Capitol right now. Your stance on stand your ground, you were there as the attorneys from the state actually were arguing this case. What has changed? Should this law have been applied?
In this case, no, the law should not have been applied, but the problem becomes, as Professor Broussard said, is that you had the Stanford Police Department who was so confused by this law that they couldn't arrest George Zimmerman after the shooting, and they said they could not. And all of this played into the trial because what happened, because of the protests of the Dream Defenders and the 2.2 million citizens that signed the petition to arrest George Zimmerman, you had many people who were disqualified from jury selection, from jury duty. They got disqualified in the first round because they participated in the rallies and because they demanded that George Zimmerman be brought to trial. So the confusion surrounding this law affected this whole case and whether or not, what happened in this case. So I agree with Professor Broussard. In this case, you had a juror who came on Anderson Cooper, and she talked about how she felt it was confusing. She felt that this law left her no choice but to have a not guilty verdict. So we have a law that everyone agreed should not have been applied to this case at all because he did not qualify under this law. But if we have a law that is so confusing to police officers and to jurors, then why have a law? If it's so confusing and so vague, then I submit that it should be repealed.
Natalie Jackson, the family attorney for the Martin family. I want to go to Senator Simmons now. You wrote this law. You know this law. You've seen this across the country, the different marches, the rallies, the protesters, the demonstrators. Do you think the Stand Your Ground law was, number one, relevant in this case? And are you hearing, what are you hearing as far as possible changes, and why don't you think it should be changed?
Thank you, and thank you very much, and thank you all for inviting me to be here to have this discussion. I think it's really important to understand first what Stand Your Ground is, because once you understand Stand Your Ground, you'll understand why African Americans are using it at a great disproportionate amount compared to the percentage they are in the population. That is a matter of fact that approximately 15% or 16% of African Americans make up our population, but in fact are using Stand Your Ground themselves approximately 33% of the time. Now, why is this? It's because they justifiably have the right to use Stand Your Ground once it's properly understood, because there's been a lot of misunderstanding. Let's first start out by saying we know that everyone is entitled to use self-defense to protect themselves here in America. What happens is it's been back from the time of the Bible, that if someone were to hit you, you have the right to stand your ground at that point in time, so long as deadly force is not used. In other words, if someone pushes you, you're entitled to push back. But the issue becomes, when you reach the point of using deadly force, what are the rules of self-defense? Stand Your Ground is simply a small but important part of the defense of self-defense. Why do I say that? Many cases do not involve Stand Your Ground. And what is Stand Your Ground? Stand Your Ground means that in the event that someone attacks you, first they must attack you. They must attack you. Secondly, you must not be engaged in any unlawful activity. And I don't mean just unlawful act. I'm talking about an unlawful activity such as running drugs or doing something like that, gang-type activity. Number three, you cannot have provoked the use of force to be able to use Stand Your Ground. Fourth, you must be in a place where you have a right to be. And by the way, we all have Stand Your Ground in your own homes. Every one of you, if someone broke into your home, you have the right to stand your ground. We've always had that. So, number four, you must be in a place where you have the right to be. You must have been the person who was attacked. And in every bit of your conduct in using deadly force to protect yourself, you, in fact, must be justifiably acting reasonably and reasonably believe that the person who is attacking you is using deadly force against you. In other words, this is only limited to truly innocent victims of crimes who did not provoke the use of force and who are persons who are attacked where they have a right to be. It is a very limited defense that is available. And once it's properly understood, why is it? Because here's what happened. Prior to 2005, Florida was a minority jurisdiction. Florida said that if you were an innocent victim and a criminal used deadly force against you, came up to you and put a knife up to your neck, you know what you had to do? You had the duty to flee if you had the ability to flee. There's an exception to the Florida rule. But Florida required innocent victims of crimes to flee rather than to stand their ground and try to disarm the assailant. The United States Supreme Court, as early as 1921, rejected the Florida position. As a matter of fact, a majority of the courts across the nation adopted Stand Your Ground and rejected Florida's position. This is not something that is new. This is not something that when I started drafting it, when Representative Baxley came to me in 2005 and I chaired the Judiciary Committee of the House, this wasn't something new and novel. That is a big misrepresentation to you. This concept of Stand Your Ground had been around for 100+ years, and the courts across the nation had rejected Florida's position. The courts across the nation, and I'll just recite to you what the United States Supreme Court said in the case of Brown versus United States. It said, if someone comes up to you and puts a knife up to your throat, that they believe that it would be wrong for the courts to second guess you in that split decision that you, the innocent victim, had. You should not be forced to turn and flee, which elevates, of course, the life of the criminal above the life of the victim, because the criminal is acting there. He's He's been the perpetrator. He's the person who is the aggressor. And so the innocent victim is forced to turn and run. If it's a woman who happens to be standing in a parking lot where she's been shopping and she gets out and a man comes up to her and says, puts a knife to her throat and says, I'm going to kill you, or I'm going to rape and kill you. Why should she, at that point in time, be required to turn and run when she could grab his wrist and disarm him? Why should we second guess her in that split decision? If she is the innocent victim, her life is just as important as the life of the criminal. And I submit to you it's more important than the life of the criminal because she was attacked. So properly understood, you see that Stand Your Ground deals with the duty to flee. Florida had the duty to flee that innocent victims were required to do prior to 2005. A majority of courts across the nation had fully rejected Florida's position. And all we did was bring Florida in line with a majority of the states across the nation. That's all we did.
Well, Senator Simmons, let me ask you a quick follow-up question. You mentioned that you could not be provoked. You had to be provoked into this use of force. A lot of people will argue that George Zimmerman provoked the actual incident that night because he was the one who pursued Trayvon Martin in the first place.
And I agree. And I agree that if you're second-guessing what that prosecution did, why did they not bring up the fact that what led up to this incident is one in which Mr. Zimmerman provoked the use of force? Because depending on which arguments, and I'm not going to redo the facts, but I'm going to say to you what I've been told. That is that, that he, in fact, was following an innocent 17-year-old child on a dark night. It was raining. He got out of his truck. Some people say that he reached for a phone. I know that when people reach for a phone in a dark night, to me, I'm wondering what they're doing. And the whole point of it is that the provocation of the use of force by Mr. Zimmerman that would have precluded him from using self-defense? But I didn't hear that argument. So I don't know about that. All I know is I have that question myself as to how the case was presented. The case was presented as to just what the fight was. And by the way, let me point out to you with respect to Stand Your Ground. Let me point out to you that if in fact Trayvon Martin had been the person who had prevailed in that fight, because whatever happened in that situation, and let's say that Mr. Zimmerman had been the one who was killed and that Trayvon was not, you know what? Trayvon Martin would have had to rely upon Stand Your Ground, because he was there and then someone reached for a phone or whatever else that provoked him. That what caused him to do was he went ahead, according to the testimony, and hit Mr. Zimmerman. In other words, he believed that he was being attacked and so therefore had the right to stand his ground rather than turning and having to flee under Florida law prior to 2005. He would have had to turn and run prior to 2005. So he would be the person relying upon Stand Your Ground. But what I want to say to you about Stand Your Ground, Stand Your Ground is in fact something that is very fair. It is pro-victim. It is the right thing. It is the common sense thing to do.
I know a lot of people are going to ask, how do you define victim, especially in this case? And a lot of people also want to know, are going to argue to the fact that, maybe Stand Your Ground, that, obviously if you are the one who is being attacked, you want to be able to push forward and say you can defend yourself, but at the same time, people can say, the attack maybe never needed to happen in this case in particular. I want to pivot now to Senator Smith. You have a lot of power in the Democratic Party in the Florida State Senate as a leader. You see the people willing to camp out, ask for the governor to actually call for a special session to repeal this law. Do you want to see that happen, and what do you think changes need to be made, if any?
Well, first I want to thank the brothers of Alpha File for putting together this forum and having this 24 years ago. I had the pleasure of crossing those sands at Johnson C. Smith University, and so I was proud when I was invited to come up here and participate. To get to the question, and a couple of things that my good friend Senator Simmons said, and hint, when I start off with my good friend, something's got to be said. my good friend.
I'm always scared when somebody's my good friend to me.
And actually, I sit next to him on the Criminal Justice Committee. We normally sitting next to each other on the Senate Criminal Justice Committee. And so, but a couple of things, and this will lead into the changes I think need to be done, and a couple of factual things that Senator Simmons said. Prior to 2005, and I love the scenario that she used, those that defend this law love the outlier case, and they love the woman getting raped in the parking lot. Oh my God, she can't run. Well, common sense, everyone in here had the same thought. When he gave this case, and he said the guy has the knife to the woman's neck. Every one of you, at least 95% of you thought, well, hell, she can't run anyway. So there is no duty to retreat. And prior to 2005, yeah, on the book, she had a duty to retreat if she could. But if he's sitting there with a knife to her neck, she can't retreat, so she could stand her ground. So you didn't need stand your ground for this. And I love, and I was on the TV with Senator Baxley, Representative Baxley, who said, oh, black people use it more, so y'all should love it. If Zimmerman was black, I'd be mad, because it's still a dead child. So I don't care who's using it. If they're wrong, they're wrong. We live in a society that, there are certain things. We were raised. When I was raised, my mom always said, you know, somebody start with you, just walk away. Just walk away. Now, if they own you and put their hands on you and you can't walk away, fight back. That's the way we were raised, you know, and that's the way society should be. If you can walk away, walk away. But don't be the judge, jury, and executioner in every situation. And what Stand Your Ground did was took that old adage when we heard that someone's breaking in your house, you know, if they're on the porch, you shoot them, drag them in, because the castle doctrine, you're good. What we did was we took that doctrine into the public's parking lot. We took gun violence and just violence into the public's parking lot. Now the changes I want to see is, in 2005 we passed the law, and I voted against it. And if you look at the voting sheet, it's so great. Representative Jack Seiler, who's now the mayor of Fort Lauderdale, wrote an explanation on behalf of myself and Representative Gelber and a couple of others, in which he kind of foresaw this. And at the end of his explanation of vote, when he voted no, if I could just read real quick, it says, Floridians to engage someone with a deadly weapon in a public arena. This provision would create a number of potential loopholes for criminals and would make it far more difficult for the police and state attorneys to prosecute these violent criminals, and even more difficult for innocent victims to recover damages from these violent criminals. This is what was written in 2005, the day they passed Stand Your Ground. And we saw that it was going to be a problem. Now, what I would like to see are some changes, and it's a simple request because you can always go back and see where the problems are and try to fix it. And I'm just perplexed that my colleagues that just think it's a perfect law. There's no perfect law. The only perfect laws are in that Bible I got back in my car. There's no perfect law that man has made, so we should go back and fix some of those laws. And one of the first fixes that I've proposed and that we should do is, well, take out the immunity from arrest and detention. That just don't make sense. That when the police come on the scene, you got somebody dead and somebody that shot him. The police, the way the law is written, and I'm sure you want to talk about this, it's written that the police cannot detain in custody. So now you got police officers in Central Florida and all around the state saying, dead person, live person said, you know, I'm standing my ground, I can't even detain this person. That's a simple fix that we should have. And secondly, the aggressor aspect of it. Aggressor is covered in .042 section of it, but it's confusing. You can't use it as an aggressor, but then if you go down to the second, to 2D, then you can use it, and you flip back up to immunities. It's confusing. We need to set it out to this is how we feel as a society. Because that night, that verdict sent two important messages to Floridians. It sent a message to Floridians that are in a certain mindset that, hey, this is something that's permissible. I can patrol my streets with a gun, and when I find somebody that looks, you know, shady to me, I can approach them, and if they come at me, I can make my day. But we have to be careful as a civilized society because another message was sent. There's a lot of people who look like Mr. Martin now that got a message that maybe I need to shoot first. As a civilized society, it is my responsibility as a state senator, and Senator Thompson and Senator Sanders, it's our responsibility to send the correct message to Floridians. So we should come back and at least amend Stand Your Ground to show, at the very least amend Stand Your Ground to show Floridians the parameters of a civilized society in Florida, because 2 messages were sent that night, and that's not a Florida I want to live in and I want to raise my children in.
We're given a lot of flexibility as far as their opening statements from the different panelists on this one. We will begin to reel them in, I promise you that. And I want to get Senator Simmons' response on this in just a moment, but first I want to go to Senator Thompson. Your district obviously deeply involved with this case and reacting to this case. What have you been hearing and what changes do you want made?
People in my district, and my district covers Paramore, where we're sitting. It covers Washington Shores and Pine Hills and South Apopka and Tangible Park and Eatonville. And people who live in these communities are concerned that they are viewed as suspicious in many cases, and people are more likely to view them as a threat. You heard the President of the United States last week talk about the fact that even in 2013, when an African-American male in particular gets on an elevator, people back up, they move their purses to the other side until they have an opportunity to get off of the elevator. So we are viewed in a way based on long history in this society as people who are more likely to be a threat to someone else. And regardless of whether people say this was about race or not, just the fact that they say that it was not does not mean that it was not. And I understand that the legislature intended to deal with the duty to retreat. That was their intent in 2005. I was elected in 2006. However, their intent was to deal with the obligation to retreat, but the impact of what has happened after the passage of Stand Your Ground has given rise to an escalating number of justifiable homicides in the state of Florida. Justifiable because people maintain that they were in fear of their life or they were in fear of grave bodily harm, and so under the law they were allowed to use force, including lethal force, and say that and then walk away because their version of what happened is the only version that there is. The other person is dead. And so in the George Zimmerman trial, unless you could prove that George Zimmerman was not in fact in fear of his life, that he was not in fact in fear of grave bodily harm, then the jury could find not guilty, and that's what happened. One of my biggest concerns is the application of the law and the disparate impact all over the state of Florida. What happens when you claim Stand Your Ground is not based so much on the merits of the case, but on who you are and who you kill. If you kill someone who is black or brown and you claim Stand Your Ground or you claim self-defense, you are more likely to be vindicated and found not guilty than you would be if you killed someone who was white. So we have a problem in terms of the application of the law. And I know you all are aware that we have a situation in Jacksonville where we have a woman who had a restraining order against an abusive husband who came to confront her about something. She fired a warning shot, did not injure him at all, but she was found to be the aggressor, and she's facing 20 years in prison under this law. So if the law can be applied so subjectively, and you can get a different outcome depending on where you are, the geography in terms of where the case is heard, and you can get a different outcome based on who you are, we have a flawed law. Yes. The moderator, and my husband's a Catholic, by the way, but the moderator said this is a discussion that we need to have. And the problem has been that our colleagues in the Florida legislature have been unwilling to have the discussion. There were many bills filed in the last legislative session that were never referred to a committee, never discussed, never heard, and therefore never reached the floor for passage, possible passage, by the full body. We need to have the debate. We need to have the discussion, particularly in light of the fact that this is now a national and an international situation, and Florida again is the scene of chaos and confusion. You know, I attend national meetings, and sometimes I go to the National Conference of State Legislators, and people will say, here comes the woman from Florida, the state that can't vote straight. So not only can't we vote straight, they say, have you all learned to count down there yet? And, you know, we have those problems, and now we have a law on the books that nobody understands. I have a 12-year-old granddaughter who asked me about this law. And you know, children understand fairness. Yes, they understand fairness. They understand the notion of who started it. So in terms of provocation, even children understand that George Zimmerman started it. In terms of provocation, in terms of who attacked whom. Except for the actions of George Zimmerman, there would be no problem.
I'm going to jump back in here. Thank you very much, Senator, for your comments. Alexander case out of Jacksonville, where she's facing now 20 years in prison for firing that warning shot. Maybe according to this law, she may have come better out had she put that shot through his skull versus through the ceiling of that home that night, because then there would have been no testimony against him. I want to bring in Kamar Williams. You have a certain perspective that no one else on this panel has of being a young African-American male. When you hear about the sentence of her laying down, I have biographies and I know when you graduated. So we're going to continue by saying, let's say, a younger African-American male who is on the panel. When you hear this decision and you see that the stand your ground law was a part of possibly the decision that was made by the jurors, do you think that this trial wound up being more focused on Trayvon Martin being on trial than George Zimmerman?
Well, I'm going to back up a little bit, and I'm glad you mentioned it, and the other panelists mentioned about the no duty to retreat or whatnot. But the problem is, dead men tell no tales. And when you have a victim on the ground and he's not speaking, and you have somebody who's saying they were the victim, saying, well, I was attacked, and based on the law, and based on the assessment of the law, the rationale doesn't make any sense. You have a law that emboldens the confused, that gives way to an unrighteous society. Now, to speak on the Jacksonville incident, the problem with that is the 10-20 life rule that applied to the young lady. And the judge, by the way, was handcuffed based on a sentence. But you go back to the jurors, and it happened in the Trayvon Martin trial, and any trial involving an African-American defendant, or any trial involving anybody, it's called cultural identity. And you saw that on B37, jury B37, when she interviewed with Anderson Cooper. Jurors do not have cultural identity with African-American defendants, especially if they feel like those defendants are the guilty party. And especially if they feel like there's a death, or there's a gunshot or whatnot, especially when our society is plagued with the image of violence and negativity. I'm sure the jurors looked at the young lady and didn't see the case, but saw everything surrounding it. Just like the juror from B37 didn't look at the case, but saw George. She didn't say defendant Zimmerman. She said George. Now that's the problem. And if any law that gives a vagary is vague and interpretation can then go to a jury who then use cultural identification to base their decision. That's not a good law.
I want to go back to Senator Simmons. You have been facing a lot of ridicule from the other 5 people on this panel about the law that you helped construct. Your thoughts on possibly limiting the fact of the right to plea, the presumed innocence in the initial, and not detaining someone. Are those changes that you would be willing to consider and even discuss with your party?
I can tell you right now that the stand your ground instruction that was in the Trayvon Martin case, the Zimmerman case, wouldn't have been any different prior to 2005. It had been the same instruction. The fact of it is prior to 2005, you had the right to stand your ground if you had no ability to retreat. And both the prosecution and the defense agreed that under the circumstances presented, that Mr. Zimmerman had no ability to retreat. So therefore, he was able to use deadly force if he reasonably believed that deadly force was being used against him, and that was the case that was tried. Now, I have my own beliefs as to, the idea that if Mr. Zimmerman were the person who provoked this, he would not even been able to have raised the issue of self-defense, and the subsequent section in the Florida statute specifically says that none of the foregoing justifications, which includes self-defense, is not available if you provoke the use of force. And of course, was there any presentation of what the provocation was? There wouldn't have been any issue as to who was on top or who was on bottom. There wouldn't have been any issue as to who was yelling and who wasn't. Because if the issue were provocation and who provoked the use of force, this case might have been different. But I'm going to tell you that the instruction would not have been any different because both sides agreed it was not a stand your ground case, because the case that was tried by the prosecution related to the fight itself, and Mr. Zimmerman was pinned to the ground and therefore had the right, according to our instructions, and pre-2005 law, had the ability, if he reasonably believed that deadly force was being used against him, to respond with deadly force. So this instruction that is read, people need to understand it would have been the same instruction prior to 2005, because they would have said, if you find that he had no ability to retreat, pinned to the ground, then he could have used deadly force.
Senator Smith, I see you chomping at the bit to jump in.
Okay, I do want to say this. I filed a bill. I sat on the Stand Your Ground task force, and we listened to Stand Your Ground. The members of the Stand Your Ground task force that the governor appointed recommended keeping Stand Your Ground, but making certain amendments and revisions to it. I filed a bill to implement those amendments. One of those amendments that I filed was to do what Senator Smith had suggested, and that is to assure that law enforcement had the obligation to thoroughly investigate and not use Stand Your Ground as an excuse not to investigate any crime. And so I want you to know that I have believed that there are certain, you can call them tweaks, revisions, glitch amendments that need to have been made. I filed a bill last fall in order to do that, and it didn't get heard. But I sure tried to get it heard. And so I believe that I'm going to file it again this year. And I think that Senator Smith and I might both be on the same page in trying to get that bill passed. Because Senator Smith, and when asked on multiple occasions about repealing Stand Your Ground, has not suggested. As a matter of fact, he had his own task force that he put together, and it did not recommend repeal of Stand Your Ground. As a matter of fact, Ms. Jackson, when asked by Lauren Rowe just the other morning on a talk show, did not suggest that there be a repeal of all of Stand Your Ground law. She wanted to deal with the issue of initial aggressor. And so we know that people who look at Stand Your Ground believe very strongly that it ought not be repealed because it's good common sense law that has been in place for 100 years in many states across the nation, and as set forth by the United States Supreme Court. So I strongly believe that there are a couple of things, or not only a couple, several things that need to be looked at with respect to this issue. One of them is the ability of neighborhood watch people to do certain things. I believe that we need to look at that, and my bill dealt with that issue.
Well, Senator, let me jump in here because every single one of the panelists has raised their hand during your comments. And I promise that I will get to you all. We're going to be just a little bit more strict with the time constraints on this one. Senator Smith, I want to give you the first chance. Are you willing to work on a bill with the senator to change it and make those modifications that he was discussing?
Yes, I mean, as I said, we sat together and I'll make any changes to it. Now, let me correct record. I'm a pragmatist. If we can get rid of it, get rid of it. I don't care. But I'm a pragmatist. I'll make changes to it. But something that Senator Simmons brought up, and I researched that because I like listening to Fox News and hearing some of this stuff. And so I had to research it. Here's the jury instructions would have been different. Very different pre-stand your ground. Under stand your ground, we heard the jury instructions. George Zimmerman not engaged in unlawful activity, was attacked in a place where he had the right to be, had no duty to retreat, had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed it was necessary to do so to prevent death, great bodily harm to himself or another, to prevent commission of forcible felony. So that kind of put the burden on the prosecution to prove. That was a burden shift. That is very fundamental. That's a burden shift. Now, pre-stand your ground, this would have been the jury instruction. The defendant cannot justify the use of force likely to cause death or great bodily harm unless he used every reasonable means within his power and consistent with his own safety to avoid the danger before resorting to that force. So, I mean just listening to the words of that shows you, I mean, one is like, hey, he can do it, let him do it. But pre-stand your ground was like, hey, you gotta really look at this situation to see if he did have to do that. That is a fundamental shift in the mind and the human psyche when you're looking at this. So the pre-stand your ground jury instructions would have been different, and they have a different tone. And so again, it's not, the Zimmerman case is over. Let's move, I'm looking at the next case, and these pre-stand your ground instructions are how it should be. You need to put the burden back on, shift that burden back on the person who took a life. Say life.
Attorney Jackson, you were there with the prosecution. You heard that the arguments that they were making as they were trying to develop their own case with this. As the senator just mentioned, he says that you didn't call for a repeal of the stand your ground law. Your thoughts on that, number one, and number two, why didn't the prosecution harp on the fact of that George Zimmerman was the one who possibly provoked this attack in the first place?
Okay, I think to answer the senator's question is that there's a duality in my role. There's my personal belief, and then there's the belief of the Trayvon Martin Foundation. One of the things that the Trayvon Martin Foundation is sponsoring is the Trayvon Martin Act, which calls for tweaks in the stand your ground law. My personal belief is that if there's a law that's so confusing that police officers don't know when to do the right thing if a child is dead on the ground, then that law needs to be repealed. So, but as a member of the Martin family team, we're pragmatists too. So we're asking for a tweaking of that law, which calls for an arrest, and also to say that you cannot be the pursuer and the provoker and be able to claim you stand your ground. And I think I want to make sure I answer the question. Is that?
As far as, we also want to talk about the state prosecution on this one, because we didn't hear them argue the provoking by George Zimmerman in this case. Do you have any insight as to why they did not go that route?
I think they did argue it. Now, whether or not they argued it forcefully enough for the jury, that might be a question. I think what we saw mostly from the state attorney, and I think why I first have to say that Annie McCory took this case and she direct filed this case without a grand jury. So she believes strongly that this was a case where George Zimmerman should be prosecuted. I've talked to her personally. But I think what Kamari said is absolutely right. This is why, for the law students in here, we need diversity in the fields of the prosecution's office, police office, and all of this, because there was something missing. When you go in front of this jury and you tell them that race is not an issue in the case, that was dead wrong. We all knew race was an issue in this case. And what I think most black attorneys learned very early is that when you have a case that involves some racial matter, such as police brutality or something like that, you cannot allow people to be comfortable and slip into their habits and their subconscious comfort zone. And when you tell a group of people that, listen, we're not going to have to deal with something that's very tough, then it makes it a little easier for them. You have to confront these issues head on. And what we've seen in the whole race debate nationwide is that America doesn't want to talk about this. They don't want to talk about these issues. Nobody wants to talk about it because it makes us uncomfortable. And we have to listen to someone, and we may have to listen to someone, and their opinions might shift our views and put us out. But that's what you have to do in a jury selection, and that's what you have to do for a trial. And I think that that was the element that was missing in this case. I think that everyone was just a little too comfortable and not looking, well, why did George Zimmerman feel he had to follow Trayvon Martin? Why was it okay? Why was it okay that everyone said, well, why doesn't Trayvon Martin have a right to stand his ground? You know, I thought that there were a lot of symbols in this case that really stood out to me. One of the witnesses that was put on by the defense, it was a witness whose house had been burglarized in 2011, a year prior to Trayvon Martin. She didn't know Trayvon Martin. Trayvon Martin had not even been in that neighborhood at that time. But that was to prove that Trayvon Martin was suspicious. It was a black boy. That was an issue with me. And I think that for the prosecution in this case, they saw that as a problem, that the neighborhood had been burglarized. I think that a person of color would have seen that as an opportunity to say, aha, this proves our point that he profiled George Zimmerman. So it's just perspectives. And I think that is why we need to make sure that as the lawyers and the new lawyers in this field, that we go into these fields and we bring diversity and we bring different viewpoints.
I'm going to jump back in here, and she mentioned race, and obviously that's the topic that everyone has avoided to want to talk about, but now we have to talk about it or we ignore it and experience the same type of thing again when another situation arises. I want to bring up a couple of different facts from a recent poll that was released today. 54%, and this is from Wall Street Journal and MSNBC report, 54% of blacks polled said that they strongly disagree with the idea that America judges people on content of character and not the color of their skin, the ideals of Martin Luther King. A change from 30% after President Obama first took office. Now, 79% in all agreed that there's no way that the people are not judged by the content of their character versus the color of their skin, and that's including 25% that said somewhat. I want to bring up a comment that Mark O'Mara said the night the verdict was actually read during the press conference after that. He said that if George Zimmerman was black, the same law would have applied and he would have never been arrested in the first place. I want to switch now to Senator Thompson. Your district obviously predominantly black. Do you believe when he says that type of comment, and are you surprised by the race relations?
I am very surprised at that comment, and certainly if Trayvon Martin had been the person with the gun, he'd be in prison right now. He would have been arrested, and the trial would have gone very quickly, and he would be in prison. So just because people want to gloss over the issue of race in America, just because we want to sweep it under the rug, and because we have an African-American president, people want to tell us we live in a post-racial society. Just because people want to pretend that there are no problems doesn't mean that there are not problems. And I want to respond to Senator Simmons' comment about the task force. The governor also has said to the Dream Defenders who are there asking for a special session that he stands with the task force that he assembled shortly after this happened. Well, let's look at the task force. Every legislator, with the exception of one, who was on the task force, voted for Stand Your Ground, every single one. The only one who did not was Representative Jason Broder, who lives in Sanford, who sponsored a bill that would prohibit pediatricians from asking parents if they had a gun in the house. So you have people who are clearly supportive of guns, and I don't think there's any problem with guns. This is not about responsible gun ownership. This is about how guns are used. So you have a task force, and you have some people on the task force who are now saying that they recommended changes, and those recommendations were never incorporated in the document that was made public. Reverend R.B. Holmes, in one case in point, was vice chair of the task force. He's out of Tallahassee, and he said indeed he made recommendations. I just heard Senator Simmons say he made recommendations, but what we're told is that the task force, and it's as if to say that it was unanimous, the task force recommended no changes to Stand Your Ground. So I think we had a problem with the composition of the task force and whether or not they could be fair and impartial and come back with an outcome that was not already predetermined. That is one of my concerns. You have to also understand that prosecuting attorneys, police chiefs, all of these people testified in opposition to Stand Your Ground when it was being discussed before it was being passed. And they also testified during the various hearings that the task force had. And yet we had no changes in this law. And so I think in order to get changes, the population of the state of Florida and the nation are going to have to speak very loudly, very clearly to say we need to revisit this law, we need to have the debate, we need to have the discussion, and we need some changes.
So Senator, I'm going to jump back in. We're calling last call for the actual questions from the audience. We're going to get to those in about 10 more minutes. I promise you that. I want to bring back in the professor. Professor, you've seen the fact that this has divided our nation somewhat down racial lines in some degree, and also by people advocating for or against guns. There's been a lot of division with this case no matter what. Most people have a stark opinion on this and don't waver either way. From a professor's standpoint, what are you telling your students as far as when you're going into a trial like this that could have potentially these types of ramifications on how to pick that jury, how to make sure that you have a fair and balanced jury to actually hear this case?
Well, I don't teach that, so I don't tell them anything. That's not my area of expertise. But I did want to go back just a minute to what the senator said. And I respectfully disagree with you saying the law is easy and once you explain it. Anytime you have to preface a statement with, let me just explain it, it's vague. And I want to show you just very briefly how it operates. Man kills lover having sex with his wife in 2012. In Brandon, Florida, a 70-year-old Ralph Wall walked in on a former neighbor having sex with his wife. After fatally shooting the man, he claimed that although the man lived nearby and he kind of knew him, he thought it was a stranger raping his wife. He was acquitted after a 2-hour deliberation under the Stand Your Ground law. In 2006, a neighbor shot a man in the stomach over trash bags. Kenneth Allen was upset that his Clearwater neighbor had placed 8 bags rather than 6 bags on the curb. The two men got into a verbal dispute. As Rosenblum approached, Allen shot him once in the stomach and once in the chest, claiming Rosenberg had tried to enter his home. He was not charged under Stand Your Ground. Neighbor kills man in front of children over dog dispute, 2009. A neighbor's dispute over dogs turned deadly when Oscar Delabono shot Shane Hoos as Hoos' 2 young children watched from his truck. He was not charged with a crime based on Stand Your Ground. This is anecdotal, and it goes on and on and on and on. I don't know how you justify this. We get to decide the kind of society we want to live in. We elect people to represent our view about the kind of society we want to live in. We need to make our voices heard so that we live in the kind of society that we want to live in. And this is what I tell my students. I also tell my students that race matters. Always has, and unfortunately still does, and probably will into the future. If you don't understand that race matters, you're delusional, and you probably shouldn't be practicing law.
Obviously, you've seen the outpouring across the country, coast to coast, worldwide even. I've heard comments from Twitter and Facebook and messages that people have sent me. And you see this room tonight packed, and this is organized in less than a week. Senator Smith, as far as the community is concerned, what do you want the community to do, and how can they help form this argument?
When I was invited here last week, my schedule just didn't permit. And I, first thing that got my attention, because it was my fraternity, I said, well, let me try to make it work. But when I really looked and saw I was at the law school, I said, I gotta make it work, because this is the group that needs to make the change. People have drawn bright just lines in the sand. And you got some people on one side yelling, no changes, no changes, no changes. I was on the ABC station the other day, and they had the chair of the Republican Party saying, no changes, Stand Your Ground is great. But then during the discussion, it's kind of like Senator Simmons, it was, okay, yeah, we can change that. Yeah, that don't make sense. That don't make, so the hard line is what's hurting this argument. But this is the group that needs to blur those lines a little bit and let people know that, no, there is a problem. The professor started with those vignettes. There's over 200. I mean, it's not about guns. I can tell you about the one in Miami where the guy came downstairs, chased the guy down the street that was still in his car radio. And the guy that was still in the car radio turned and swung the bag at him, and they stabbed the guy to death. And they said, understand your ground, once the guy swung the bag, you know, that was an aggressive move, and he had the right to kill him. To kill him. Came downstairs, chased him down the street, killed him over a car radio. After you get so many of these, since 2005, after you get so many of these, there's something wrong. Something's wrong, and you need to go back and look at it again. But this is the group that has to contact legislators. This is the group that's got to call and write Senator Gates, the President of the Senate. You got to call and write Senator Evers, the Chair of Criminal Justice Committee, Representative Gates, who's the Chair of the House Criminal Justice Committee, and Will Rutherford, and let them know, don't be afraid of the debate. Senator Simmons, to his credit, he filed a bill. I filed a bill, and at every meeting, I almost hated walking in because he'd grab me, man, we need to get together on our bills and put them together so we can get them heard. He was actually trying to make changes this year. But the leadership, those that are afraid of looking soft on crime or looking afraid of being soft in front of the NRA, need to know that regular people see that something's wrong. In my law firm, I'm the only African American. I think I'm the only Democrat. They're all crazy now. And I got into it with them after the verdict. But then all these rich Republican lawyers, I ain't one of the rich partners. All these rich Republican lawyers all said together, yeah, maybe we need to make some change. Maybe we need to do something. So this group here tonight, this educated group, this thoughtful group that's not out, you know, just saying anything, are the people that need to reach out to these legislators.
Senator Simmons, when you see the drink offenders locked inside the rotunda, they've been there for more than a week, and I spoke to one of them as I was driving here today, said they have no timetable on when they will leave. You yourself just said, and the senator backed you up, that you all are going to try to work on these modifications. Do you think that type of pressure, the people staying inside the rotunda, do you think that the governor should call for a special session to go ahead and take action on this now?
Understanding what a special session does in the speed and the need to have something worked out in advance, it just doesn't work to do a special session, but it certainly works to go ahead and get started. We're going to have committee meetings that start on September 23rd. And this is an entirely appropriate thing to have a full debate and conversation on. And I can tell you that I filed a bill in order to correct the things that the task force pointed out and that we discussed in the task force. I think it's important, so that you'll understand, for us to discuss the ambit of ability of a person in neighborhood watch to do things like carry a gun or to follow or pursue somebody. I think it needs to be discussed, and I included that in my bill. I think it's clear that we need to make sure that law enforcement understands it has the duty to investigate fully and completely and charge anyone whom they believe they have probable cause to believe committed a crime. You don't want to just arrest everybody you see if there's been some kind of event. You don't do it. But if you have reasonable cause, and that's what the law in our Constitution says, you shall not arrest somebody or detain them unless you have reasonable cause to believe they committed a crime. But you should not ever have stand your ground as a limitation upon arresting anyone who law enforcement, after investigating, believes reasonably that they have committed a crime. I think we've got to educate law enforcement. I think we need to have a dialogue as to whether we have 12-member juries in order to get a greater cross-section of our... It's not going to hurt anyone to have a 12-member jury. And that was done back, I don't know, 20, 30 years ago in order, I guess, to cut costs for the judicial system. But the fact of it is that we need to have a dialogue on any kind of case that like this as to whether we should have a 12-member jury to more assure that we have a better cross-section of the community. And we need to have a dialogue about mandatory sentencing. And so these are things that that I believe need to be discussed and debated. And certainly, when you look at it, that Senator Smith has said that that his own task force did not recommend the repeal of stand your ground, but in fact recommended revisions to it. I'm open to that. I'm absolutely open to that. And with respect to Ms. Jackson, who said that the Trayvon Martin Foundation is only asking for a portion of the bill to be, the law to be changed. So I can say to you that when you have a law, as we do, that says now, which is consistent with the majority of the states across the nation, that if you're not engaged in an unlawful activity, if you are where you have a right to be, if you did not provoke the use of force, if you are the person who was attacked by the other person, in other words, the aggressor, and that you must have acted reasonably, both subjectively and objectively in every way in using your force. In other words, you must have believed that your opponent, the person who was the aggressor, who was the attacker, that he was trying to take your life. Then you, as the innocent victim, have the right to have that choice to either flee or try to stand your ground and disarm that assailant. Once you understand that the law is limited to that small, discrete individual who is a true innocent victim, then you say to yourself, wait a second, this does make sense. And you can see why Senator Smith's task force said, let's revise it, let's correct some things that need to be corrected. And I admit that there are some things that need to be corrected, or I wouldn't have filed a bill to do that. And as Ms. Jackson said on behalf of the Trayvon Martin family, I look at it and I say, what, can we further define what provocation is that precludes somebody from being able to use self-defense? I think we can look at that and have a debate about that. By the way, the provocation provision, that wasn't in the Stand Your Ground bill. I didn't use the word provoke on that. It says that you cannot use stand your ground, you cannot use self-defense if you're the person who provoked the use of force. The fact of it is that's been around in Florida law for a long, long time, long before stand your ground. So, as to the definition of provocation, maybe we should look at how broad or how narrowly we should define that word, or if we should define it at all or leave it to the jury. I can tell you that a lot of decisions are made in a trial where someone can sit back later on and ask the question, why wasn't provocation a bigger part of that trial?
Yes, we all play Monday morning quarterback looking at the actual defense. Before we go to the questions from the audience, I want to bring in Mr. Williams one more time. You're part of the new generation. What do you tell young males, young black males, young people in general to prevent this from happening again?
Well, it's kind of tough because you can't account for people's ignorance. So, you can tell them, dress a certain way. You can tell them speak a certain way. You can tell them act a certain way. But then you're telling them not to have a personality. And I know for one, that, my mother's in the audience, she can attest. At 17, I wasn't a refined individual. So,
like he is now.
That's debatable. But one of the things I would say is to take account your situation. And I'm going to say something that's very difficult to say. I think if Mr. Martin would have had a lot more life experience, and he didn't get the chance to, he would have recognized an individual who was trying to amp up the situation. And I know personally speaking, I've been in situations where you've seen people who want to take it to another level, and you internally have to say, you know what, I'm gonna dial this back because this can get pretty ugly. And Trayvon acted like a 17-year-old young man. If he I'm sure he's popped off at his father when at 17, so imagine a stranger telling him something he didn't want to hear. And it's unfortunate, but if I had to tell and sit down, and you know, we do have a program, Young Men of Distinction, and we do mentor them, but we tell them to assess the situation, use your common sense, use your brain, because this person may not be using theirs. And you have to outthink yourself in a situation. And that's the unfortunate thing, but you know, that takes time and maturity unless somebody sits down and tells you specifically, this is what you have to look out for. And unfortunately, African American young men are the only group that I know have to have that conversation.
This question is for the three senators, comes from our audience. This person did not write their name, so I'm just going to read it. How realistic is it that stand your ground laws can be repealed, amended in such a partisan climate? Are there any less but equally effective changes that we can actually push for? And any of the senators can answer this.
I can answer that question because I believe that that there is a viable chance, and I spoke the other day with Representative Baxley, and I strongly suggested to him in the House of Representatives that they needed to do a bill, and that I would do a bill, and I'll do it with Senator Smith, that will make certain revisions to this so that it can improve upon it. Because I've never suggested that the things that I've drafted are perfect. I can tell you that this is a very, very good law. It's a law that his own task force did not recommend repealing, that the Trayvon Martin Foundation has not recommended repealing. It is a law that can always stand some improvement. I look forward to working with Senator Smith in order to improve this very, very good law and make sure that that there are not any kind of situations where it's unfair to any person who either is a victim or who is a person who is an accused.
Senator Thompson.
And there are 160 people who can change this law. Those are members of the Florida legislature. 40 of us are in the Senate, 120 are in the House, and you can get to all of them. There's a website that has everybody's name, address, email, phone numbers, etc. As Senator Smith said, you want especially to get to the Speaker of the House, the President of the Senate, and the chairs of the criminal justice committees to say, here are the bills regarding stand your ground. Because if they're not heard in committee, as I mentioned before, they don't get to the floor, they don't get, you don't have a vote by the full body. And so it is very important that you are engaged. The young people who are sitting in the governor's office, I think, are doing a fantastic job, and it's wonderful to see young people engaged. And I arranged with a local church to send them lunch because they're sitting there without a cafeteria, sleeping on the floor. Someone sent them toothpaste and toothbrushes, and Mount Pleasant Missionary Baptist Church, they wanted tacos. Mount Pleasant sent them 200 tacos for lunch. So we want to encourage that kind of engagement and then get to the people who can change the law and say that you want it changed. And by the way, many of us are on the ballot in 2014, including Governor Rick Scott. And we started the discussion with the importance of your vote. And you want to be sure you vote for people who are interested in your concerns and who understand your community.
Your two colleagues here. We live in a very partisan country, and this state no different, clearly. Does this have any chance?
I think a repeal of stand your ground would have no chance because of the partisanship, and I try to put myself in the mindset of Republican House member. If they vote for a repeal of stand your ground, now they get the NRA and their Tea Party people doing the primary on them, so that's not going to happen just politically. But because of all of the national and international attention, I think we have an opportunity to at least have the discussion. And a shameless plug, on Twitter, tweet everything, hashtag hear the bill. I'm trying to get that going. So hear the bill. When you tweet to the senators or House members, hashtag hear the bill. Because I think if we have the discussion, the things that need to be changed make such common sense, it's going to be hard for my colleagues not to vote for it. And the prime example was after the Casey Anthony case. We actually did a committee on it. I mean, we did a select committee, and I served on it because Floridians were outraged as to the outcome of that case. We did a select committee. We took testimony, 3 different committee meetings, took testimony from experts and everything, and we changed the law based on the outrage from the outcome of a judicial case. So we did it a couple of years ago, another case from Central Florida, where people weren't happy with the judicial outcome, and that's all we're asking for. And I think there's an opportunity because of the national and international attention to it to at least get a hearing. If you get me a hearing, we can get some change, because what we're asking for is just makes too much sense.
We've got 3 more questions and we're going to end the topic and the discussion for the night. I want to go to the end of our panel. Professor Natalie Jackson, I want you to answer this. This is coming from our audience members. It's a 2-part question. A child was the victim in this incident on August, and a little more than a month from now, when school opens in Orange County. What do we tell our children to keep them to feel safe in regards to this law and our streets and states of government? And also, through the lens of this case, how do we begin to differentiate between aggressors turned victims and purely innocent victims in response to provoking and the use of force?
I listened to Kamara's explanation of what we tell young men. I would submit to you that young men don't want to hear what they should do. They want to hear that they're equal to George Zimmerman. If George Zimmerman had a right to be in that neighborhood, so did Trayvon Martin. And I think that is the problem when we start telling our young men, especially our young black men, that they don't have the equal rights. That's what we need to have the discussion about. It disheartens me when I hear people say, well, what did Trayvon Martin do for 4 minutes? We don't live in apartheid South Africa where Trayvon Martin has to go home and George Zimmerman can stay outside. That is what we need to demand. And I will tell you, I'm so proud of the Dream Defenders, because what the Dream Defenders are saying, they're saying repeal this law. And the reason that they're saying this is because they feel that this is a law that's used disproportionately against black people. And they felt in this case specifically that you had an innocent kid who was killed and no one did anything. The police didn't do anything. The jury didn't do anything. That is disheartening to young black men today. And that is what, until we start talking about the real issue, these laws and the tweaking of these laws and the tweaking of, it doesn't matter, because it's really the tweaking of the attitudes behind these laws. Our system works. It's the people behind the system that disrupts the system. And I know that as politicians and as lawyers, you know, we have to deal with what's pragmatic. But I would submit to you that the young black men who are affected by this and worried about this law, which I have kids coming up to me saying, what about me? Can I walk home now? Yeah, I would submit to you that they care about whether or not they are equal citizens, and not so much about stand your ground law or minimum mandatory laws.
Professor?
Yes, I also think that we have to be intellectually honest. I am a parent. I have birthed 3 children. And the hardest thing for a parent to do is to look at a baby and say, this baby's ugly. Because you birthed it. Stand your ground is ugly. I'm sorry, you birthed it. It's not a good law. When you can say there are 200 cases where this law has been used in a way that makes us the laughingstock, not just of the nation, but of the world, it's time to just call it like it is and say that baby's ugly. And I think what we have done, and I don't know what you tell your children. I know that your children lose their innocence. I have sons from day one. Walk this way, don't walk that way. Look this way, don't look that way. Smile, be nice. So they have to, as was said earlier, you got to alter your personality in order to just survive. So what you have to do with your children is they have to lose their innocence. And you have to sit them down and have a real conversation with them. But we've got to be intellectually honest and call it what it is. This is not a good law when we've got to have a panel discussion about it. I'm so delighted that we did have the opportunity to have this discussion, and I hope we have many more, because we've got to open our minds, we've got to look at each other, accept each other, deal with each other, and to survive together or perish in a hail of bullets.
We've got our 1 minute final wrap from each of the panelists. Professor Broussard, we'll start with you.
In the early 1950s, a young man by the name of Emmett Till was murdered. And Emmett Till's mother had the courage to say to the press and to anyone else who would listen, we will not close his coffin, we will have it open so that the world can see what happened to my son. What happened with this was it spurred what is commonly referred to as the second civil rights movement in this country. This, that has happened to Trayvon Martin, is so important because it's a watershed moment that we can use. We can either go back to sleep or we can use this time to start a new movement, to decide who and what we want to be as a country, to just say no to the violence that laws like this promote. So we can take this opportunity for what has happened to Trayvon Martin and make some changes, some real substantive changes in this country, so that we will not be the laughingstock, so that we have credibility, so that we have the ability to go around the world and spread democracy and not be intellectually dishonest about doing so.
Professor, thanks.
Thank you.
Ms. Jackson.
I would just like to echo what Professor Broussard said. I will tell you that this movement it is not a moment. It needs to be sustained. Everyone in here can help with that. They can help with the marches, they can help with the petitions, they can help with the registering to vote, they can help with the contacting their legislators, they can get on Twitter, all the social movement. Right now, everyone has power. And I just hope that everyone continues this momentum and continues this passion and this power to change, because as people, we can do it.
Senator Smith.
The one thing about Stand Your Ground that it does, it sets an attitude. And I started off by saying, the jury sent two messages. Stand Your Ground sets an attitude, and we live in a civilized society for a reason. We have a compact with each other called civilization. And in a society where you promote and embolden people to have violence in the streets. When I leave the University of Florida versus Florida State football game, and a gator runs in my face doing the gator chomp, I don't think it's right for me to have the ability to pull out my gun and shoot them dead. Because when they were coming at me chomping, I would felt in fear. That's the kind of attitude that Stand Your Ground promotes. Cut it whichever way you want. That's what it promotes. We've taken the council doctrine into the streets. We've made it very subjective for someone to look at me or someone that looks like me to say, you know what, I felt in fear. Because one of the most feared things on this planet look like me. And when you make it subjective, now you're giving permission to use your subjectivity to stand behind taking a life. So Stand Your Ground is important. Even moving on from this case, how we set the attitude and how we set our compact for civilization. And lastly, to the law students here, you got homework tonight. Look up jury instructions pre-Stand Your Ground.
Yeah.
Jury instructions for self-defense was fundamentally different prior to 2005. You can then speak to people that say, oh, it would have been the same pre-Stand Your Ground. No, jury instructions were fundamentally different. They set the wrong tone. So law students, go look it up tonight. Y'all professors, some of my classmates, y'all professors, y'all quiz them on it tomorrow.
Senator Thompson.
Well, I think we have two choices. Either the state of Florida will act or the nation will act. I met with tourism leaders last week. They had met with a larger group of legislators, but I had an opportunity to talk with them one-on-one. And we talked about the fact that when people like Stevie Wonder says, I will not perform in Florida as long as this law is on the book. We talked about the fact that there are conventions slated to come to Florida who are now questioning whether it's safe for them to come here and have their people walk the streets. So the state of Florida needs to take this very seriously. We need to be willing to sit down, have the discussion, have the debate, revise the law, since that's what we're calling it, amend the law, or the nation is going to act. We saw it with Nelson Mandela. We saw it in other instances, and I think there are people who are saying we don't feel safe coming to the state of Florida, particularly young men, and walking down the street because there's a law that will allow people to kill us and claim that they felt threatened, and then they walk away.
Senator Simmons?
Since Stand Your Ground was enacted, the violent crime rate in the state of Florida has dropped in most cases by 30%. And so, no, this is in Florida only. I'm sitting here looking at the Department of Justice Uniform Crime Reporting Statistics. It's for the state of Florida. So to go ahead and suggest that that this state is lawless as a result of Stand Your Ground is just simply incorrect. This is a law that's been in most states for 100 years. To suggest that there's some kind of lawless activity is simply incorrect. What I ask you to do is apply this law in your mind to yourself. If you're not engaged in an unlawful activity, if you're where you have the right to be, and you didn't provoke the use of force, and you were the person who was attacked, and you acted reasonably in every way, and you believe reasonably that the person who attacked you was in fact using deadly force against you, why would you be forced to run in that situation rather than try to stand your ground and disarm that person who has attacked you? Simply stated, it is a very reasonable piece of legislation. I look forward to working with my good friends and colleagues, Senator Smith and Senator Thompson and others, to try to change parts of this that I believe can be improved. You know, this is a good law, but how can we make sure that it works right? That's what we've got to do. It is a good law. Let's make sure that it works right.
Mr. Williams?
Since we're in this intellectual setting, I want to have a theoretical thought with you. Does an imperfect law that's read by an imperfect jury that gave way to an imperfect verdict give way to a perfect society? That doesn't sound like it makes sense, does it? Going forward, it's important that we look at the laws, not only collectively but individually, and figure out, not saying that every law it needs to be changed, but some need to be amended. When this country was first founded, there was a lot of laws that were in the books, and I wouldn't be here. So I'd ask that Senator Simmons, and it's great that he came here and he had an open dialogue, and it's fantastic that he's even admitted that he's open to conversation. But a conversation needs to turn into action.
Yes.